Welcome to Ballantyne Law, clear, practical legal advice that works.
Can you see my belly? Do you think I have his consent? Do you think there's a consent issue here?
Hi, I'm James Ballantyne and I'm the Managing Director of Ballantyne Law, and today I'm joined by Sidnee Jennings, who's a Senior Associate in our team, and Sidnee has some exciting news. She is about to leave us and go on maternity leave.
I could have shared that news.
Sorry?
It was exciting and now you've taken it away from me.
I'm sorry. Maybe you could share the news of what you're having. I thought we could have a chat.
It's a boy.
Today. Oh, do you have a name? James?
No.
I thought we could discuss today some of the legal issues that sometimes arise. New parents should start thinking about either before or shortly after having a child. What do you think about that?
Do you mean just from a legal perspective?
Yeah, well, no, from an accounting perspective.
Or you can put perhaps practically stuff to buy.
No, legal issues is probably a good place to start. As someone who's about to become a new parent, what would you be recommending to other new parents out there to think about from a legal perspective, how they should be thinking and what they should be doing?
I'd probably recommend that they think about their estate plan and whether they've got a will and enduring power of attorney in place, and if they do, if those documents account for the fact that they're about to have a child.
Okay, let's look at a worst case scenario. What happens if someone has a child and unfortunately they pass away and they don't have a will? Well, what we have in that scenario is an intestacy, and under the rules of intestacy, if they have a partner and they have a child, the estate's going to be divided between, not necessarily equally, but between their partner and their child. The first $150,000 of the estate will go to the partner, and if there's one child, the balance of the estate's going to be divided between that child and the partner, and that can create some real administrative headaches for the surviving partner, because they will own potentially the family home in their own name and in their name as trustee of their child. When the child reaches 18, that property has to be transferred to them. It can be a real nightmare for people, probably even worse than losing the partner, to be frank.
If you had to pick one, the other.
Wills don't necessarily need to be hugely complicated, particularly for young families, but I think it's important that people understand that estate planning isn't just for old people or rich people or anything. I think anyone who owns property or has assets or want to look after their family should be considering their estate plan. And I think having children, having your first child, means that it's probably a good idea to start thinking about how you can look after them if you're not able to anymore. So with that in mind, what are the kind of things that people should be thinking about when they're taking into account their estate plan once they're new parents?
Firstly, guardianship. They should think about if the worst case scenario, something happened to both of them, who they would want to take care of the child.
Is that the executor, or is there...
It could be the executor. It doesn't have to be the executor. There should be an executor, obviously. If you consider that the person most able to administer your estate because they're very organised, or they have a financial background, or they're just a sensible person, may not necessarily be the person that you'd like to raise your kids in the way that you'd like to raise your kids. So in that instance, of course, they might be different.
So you can have a separate executor and a separate testamentary guardian, and they could be the same person or they could be different people depending on the circumstances. And that would mean that the executor is the person who deals with the estate and the money, and the testamentary guardian is the person then who is responsible for the child and dealing with the children.
And in fact, it can be beneficial, I think, considering you're leaving your children, who are obviously going to be upset, and a person that you trust who probably is also upset by your passing. It would be nice for them perhaps to have a level of separation from, especially if you've got significant assets, a level of separation from the assets, so that if, for instance, your 15-year-old child you've left behind is asking for a brand new car that they know you could afford, at least the guardian has the stopper of being able to say, oh, well, I asked the executor, you know what they're like, they said no.
Okay, so the executor can be the bad guy. The guardian can maintain the relationship with the children.
That's what I would be doing.
On that point, it's not possible necessarily, or not a good idea in any event, to leave potentially a reasonable sum of money to a child. I have an 11-year-old and a 15-year-old, and I don't think either of them would be particularly good with a large sum of money. What happens with the money if the children are the beneficiaries?
Well, the children are, as you've mentioned, beneficially entitled to the cash or the assets, whatever they may be, but on the passing of both parents, as the case may be, the executor will be required to hold those funds on trust for their benefit.
What age do the children become entitled to receive their inheritance then?
Well, if you don't specify an age under the will, then it would be at 18.
But you can specify an age under the will?
Yeah, we recommend to parents that they do consider their children carefully, but most of the time parents are more willing to look at 21, 25, we've got some 30. We had a request for 50 the other day, which
Really?
which seemed odd, but who are we to deny that? Yeah.
So if the estate is, let's say, some cash or some shares, and the parents state that the children won't receive it until they're a certain age, say 25, does that mean until they receive the money, those funds are locked up in investments and can't be used?
No, the funds can be used for the benefit of the children before that age, and should be. And in most instances, parents who come to us are concerned about that, and we let them know that certainly the guardians of the children shouldn't be financially put out by the fact that they've passed away.
It's just that the executor or the trustee gets to decide how those funds are used rather than the children themselves.
Yes, yeah.
Which is probably sensible.
Yes.
Okay. In addition to the will, what other things should new parents be thinking about as part of their estate plan?
I think it could be a valuable trigger point to consider your superannuation. A lot of people at that age, might have been accruing significant superannuation just in the background, and they should consider whether they have binding nominations in place, or what their super fund's default is in the event that they do pass away.
They may have insurances in their superannuation as well, which could result in a reasonable amount of money being payable. And what about powers of attorney? Yes,
they should consider their enduring powers of attorney and advanced health directives as well.
Okay.
The question from the audience was, have I done my will? And the answer is, I did my will 3 years ago, and it gives everything in the first instance to my partner and then to my children, which at the time did not exist.
Well, they still don't.
But as of what will likely be a few weeks away, will exist.
Okay.
And so I won't need to do a new will.
Good.
Which is good because James charged me for it.
Did I?
No.
Can you tell me a little bit about guidelines to guardians, which is an additional part of people's estate plan that we do?
Yeah, we encourage parents who are thinking about testamentary guardians to think about whether there are any big decisions or small decisions that are important to them that they would like to make clear to the people that they are appointing as guardians.
Things like schooling or
religion,
culture,
healthcare,
who's involved in the children's life.
Yeah, and we encourage clients to have discussions with those guardians beforehand anyway, and make sure they're comfortable with the people they're naming. That's not required. They can just have it, show up once they go.
It's a good idea though.
But certainly to make sure if anything, just to make sure you're comfortable that the person you're naming would have respect to those wishes, then yes.
Okay.
The takeaway from today is that becoming a parent is scary. Tick one thing off your list so that you don't have to worry about it.
That one thing should be do a will and an enduring power of attorney. Don't worry about the pram.
Yeah, exactly.
Or any of those things.
Yeah,
Come and see a lawyer and get your estate plan done.
Exactly.
Okay. For more legal insights, subscribe or visit ballantyneLaw.com. We're here to help.